behalf of the committee, I welcome everyone to this public hearing into the Territory Coordinator Bill 2025. I welcome to the table to give evidence to the committee from the Heritage Council NT, Mr. Randle Walker, Chairperson. Thank you for coming before the committee. We appreciate you taking the time to speak to the committee and look forward to hearing from you today. This is a formal proceeding of the committee, and the protections of parliamentary privilege and the obligation not to mislead the committee apply. This is a public hearing and is being webcast through the Assembly's website. A transcript will be made for use of the committee and may be put on the committee's website. If at any time during the hearing you are concerned that what you say should not be made public, you may ask the committee to go into a closed session and take your evidence in private. Can you please state your name and the capacity in which you are speaking today?
Randle Walker, I'm the Chairperson of the Heritage Council NT.
Thank you. Before we begin, I'd like to just quickly introduce my fellow committee members. We have the member for Gwoja, Mr. Chansey Paech. We have the member for Drysdale, Mr. Clinton Howe. We have the member for Johnston, Justine Davis, and we have the member for Wanguri, Miss Ollie Carlson, joining via telecommunication today. Mr. Walker, would you like to make an opening statement?
Yes, I would. Thanks, and thanks for the opportunity to speak before the committee. Whilst I appreciate the discussion may expand further on regarding the Heritage Act, the Council's submission is primarily focused on the belated inclusion of the Heritage Act in the schedule of bills that will fall under the Territory Coordinator Bill. Just some background on the Heritage Act itself. It's the principal legislation that protects tangible or physical cultural heritage in the Northern Territory. The Heritage Act provides a considered, balanced, evidence-based and consultative approach to the management of cultural heritage. The Act establishes classes of protected place, a criteria for assessing significance, and a process for approving works. The Act also establishes the Heritage Council and provides compliance and investigative powers to heritage officers. Protected places included places that can be nominated on a case-by-case basis, and there are 306 declared places on the Heritage Register. And since 2011, when the new Act came into place, there's been 73 referrals to the Minister for approval, 38 of which have been approved. Also under the Act is the protection of Aboriginal archaeological places, of which there are over 8,000. So they're not individually put onto the register, but there is a database of all those archaeological places. It's an obligation of the Heritage Act to notify the Department on the discovery of Aboriginal and Mackay archaeological places, and this allows the Department to understand the resource and provide informed advice to land users and developers of those archaeological places. Under the Heritage Act, the functions of the Heritage Council include, but are not limited to advise the Minister on matters affecting the Territory's cultural and natural heritage, to advise the Minister on the conservation, use and management of heritage places and objects, to assess work applications that will impact heritage places. So it's probably important to remember that the Heritage Council itself is only the decision maker for minor heritage works. If it's classified as major heritage work, it's then a recommendation to the Minister itself. And we meet 4 times a year to assess and make those assessments, but also have out-of-session meetings when work assessments are more time frame dictates that we meet more sooner. I'd just like to then quote some extracts from a submission. Significant, the Territory Coordinator consultation paper released in October 24 sought to exclude the Heritage Act. It stated, furthermore, it is proposed that the TC's powers will not apply to the Northern Territory Aboriginal Sacred Sites Act 1989 and the Heritage Acts 2011, being Northern Territory legislation that seeks to protect Aboriginal rights and interests. However, the guide to the Northern Territory Coordinator Bill dated 14th of November 2024 then states that, while the limitation currently applies to the Heritage Act 2011, we would welcome your feedback on whether this should remain in the final bill. Following the consultation report for the draft Territory Coordinator Bill released in February 2025, went on to state that the status of the Heritage Act 2011 and Northern Territory Aboriginal Sacred Sites Act 1989 in the draft bill attracted a variety of comment and were often discussed together Several stakeholders supported the removal of the limitation of the use of powers under the draft bill regarding these acts, particularly for prioritisation progression decision requests. Some suggested all legislation should be included, but others argued to maintain the limitations on powers in relation to both acts. That's page 7. The draft bill, released in February 2025, includes the Heritage Act in its schedule, meaning it will be captured in the Territory Coordinator Act 2025. And it's important to clarify that the Heritage Council was not consulted about this change, first flagged in the Guide to the Territory Coordinator Bill, nor provided any details on specific feedback referred to in the consultation report. However, the original submission made by the Heritage Council to the Territory Coordinator consultation paper remains valid and has been provided. In the Heritage Council's submission, we argue that in order for Aboriginal rights and interests to be protected, all provisions of the Heritage Act must be exempted from the Territory Coordinator's powers, not only those provisions, sections 17 and 18, that provide blanket protection for Aboriginal and Mackay archaeological places and objects, regardless of whether they are listed on the NT Heritage Register or not. And as I mentioned before, that's over 8,000 Aboriginal and Mackay archaeological places and objects. It's also important to remember that within the Northern Territory, Aboriginal places and objects are intertwined culturally and natural values in at least 25% of all declared places, and objects in the NT Heritage Register have both historical and Aboriginal heritage values. Some examples of those places with intertwined values are Gurindji Wave Hill Walk-Off Route, Alice Springs Telegraph Station, Fort Dundas Panata, which recently celebrated its 200th anniversary. And it's also important to remember that the Heritage Act intersects with Commonwealth legislation. So 29 places in the Northern Territory, heritage places, are currently protected, of which 12 are under the Commonwealth Heritage List, 5 under the National Heritage List, 2 under the World Heritage List, and also 10 under the Underwater Cultural Heritage Act. Most of those places are already also on the NT Heritage Act. So impacts on those particular places will therefore also involve repercussions under both Territory and Commonwealth legislation. And we believe that has also the potential to further, work against the intent of the legislation and further delay projects. Our recommendation is, were the functions of the Territory Coordinator to extend over all or any aspect of the Heritage Act, there's risk of irreversible damage to the diverse range of places significant to Aboriginal places in the Territory. Following recent high-profile national incidents as the damage to Gumlum Falls in the Territory, in Western Australia, Gumlum Falls in the Northern Territory and the destruction of Juukan Gorge in Western Australia, the Council believes the applications of the power of the Territorial Coordinator to the Heritage Act would expose the Territory to legal action which may create project delays and present unacceptable risks to the Territory's reputation. It is important to reflect that the Territory Coordinator consultation paper excluded the Heritage Act because it was understood as being Northern Territory legislation that seeks to protect Aboriginal rights and industry. In this context, the Heritage Council notes that the functions of the Legislative Scrutiny Committee, as detailed in the Terms of Reference, considers whether a bill is consistent with principles of natural justice, has sufficient regard to Aboriginal and Torres Strait Islander tradition, and does not adversely affect rights and liberties or impose obligations retrospectively, and does not confer immunity from proceeding or prosecution without adequate justification. Based on the government's original position that the Heritage Act will be exempted to protect Aboriginal rights and interests, serious consideration should be given to whether its recent inclusion creates any conflict with these principles. And for this reason, those outlined earlier, the Heritage Council recommends that the functions and powers of the proposed Territory Coordinator should not apply to the Heritage Act 2011. That's my introductory statement.
First question, thank you for that, Mr. Walker. In your submission, you talk about the maximum time under the Act for an assessment to be made is 10 months, and that's the cumulative 6 months, 28 days, 30 days, and so forth. Do you have any, I'll take an anecdotal, how long a normal assessment would take place in the Territory? Are there the timelines that you've experienced in your time on the Heritage Council? Is it traditionally it's within a couple of months? You've seen them blow out to years. What's your experience been in terms of timelines for the...
Yep. We have
Do you want to add, Mr. Chair, like timelines and what the process is?
The process is quite detailed. I was just wondering about...
But each heritage thing is a particular different set of circumstances or considerations.
Yep, so once a nomination is received, yes, there have been a lot of assessments that have taken a lot longer, and that's dependent on the circumstances of what's been nominated and who's the level of consultation that's required. So that, yes, there have been some that have blown out, and we've informed the nominators that the process is taking a lot longer. Some of these places are also remote, and as you can appreciate, particular times of year, it's not appropriate to send people there, or not safe to send people there, and it's also a department with a limited budget that has to do these assessments, and some of them do involve going to quite remote areas.
And what's in your time, Mr. Chair, what's the longest you've seen the process take?
I couldn't actually comment on that. There's probably some that have been there since I joined the thing in 2021.
Yeah.
But those would be ones that the department are prioritising lower at the moment.
Yeah.
And they're concentrating on the ones that are of higher significance.
Yep. Thank you.
Any further questions?
Sure. Thank you, Mr. Walker. You expressed concerns about the erosion of free, prior and informed consent. How would you like to see the free, prior and informed consent respected and incorporated into the bill, particularly in relation to projects that may affect traditional owner lands?
I believe the current processes do provide adequate consultation with the communities and the affected parties. We do, when proponents come forward with applications for works, we do check that the appropriate cultural authorities have been attained to do work. So that's a prerequisite of applications for works on heritage places and sites. So yes, we already incorporate that into the processes and are happy with how that works at the moment.
Yeah. So the ideal position is that heritage and sacred sites are enshrined in the legislation as exemptions. Correct. And just in terms of a practical sense, obviously the Northern Territory is enormous in landmass, and where developments may be identified to be undertaken under the proposed legislation, a development could, during the process of construction, of land clearing, of surveying, find objects of historical value. Under the proposals, that process could be completely overlooked and those objects and artefacts could be removed without any assessments being undertaken to the social value and the historical value. I'm just referring, I'll give an example to help. The Territory has a very proud history with the Macassans and particularly the Yolngu people. Any development in that area could expose a historical site which would be of enormous heritage value. Under the proposals, Territory Coordinator could order those objects to just be scooped up in a bucket and moved away, and there would be no provision for heritage to do a survey to look at the protection of those works. Is that the concern of the Heritage Council?
That's a potential concern, yes.
Yeah.
Any further questions?
Yeah, sure.
For Gwoja?
Yep. I'm just building on from that as well. Mr. Walker, you talk about the bill fails to adequately engage traditional owners before the development of the infrastructure coordination plan. Can you elaborate on why the timing of this consultation is problematic and what you believe is an appropriate process for involving traditional owners in decision making?
We abide by the principles of free, prior and informed consent.
Yep.
And consult with land councils where required, or even local traditional owner groups. And again, we insist that applications for work have undergone the correct consultation to traditional owners for that area, and even in approvals for work that we put in prerequisites that, again, as you said before, if archaeological objects are located during the process, that work stops and there's a proper assessment done of what is found before work proceeds. So we would not like to see that superseded with another process that effectively ignores the rights of the traditional owners.
Yeah, and following on...
May I just check?
Yeah, sure.
With regards to the Heritage Council and your own opinion of the bill, with obviously the concern primarily in the submission is relating specifically to the inclusion of the Heritage Act. Obviously, that's the topic. Mm-hmm. With regards to if that was not included on the schedule, does the Heritage Council have a position on the rest of the bill, or is it specifically because of? I can see the why your focus will be drawn to that provision, but I'm just in general, is there a view of the rest of the bill?
No, we don't have a view of the rest of the bill other than that it should be excluded in toto because of how it impacts on, it's not just the traditional view of Western heritage of the 309 places that are just sort of declared, but which also have Aboriginal characters about them. But it's the 8,000 archaeological places that are also underneath the Heritage Act as well. I think there's a lack of understanding out there in the public that the Act is umbrella over the two types of cultural heritage.
And just, you spoke about litigation risks and costs. So the submission indicates that the bill may increase the risk of litigation, especially in conflicts with federal laws like the Native Title Act and the Environmental Protection and Biodiversity Conservation Act. Do you have any examples how that could play out in practice, Mr. Walker?
No, I'm sorry.
No, that's completely.
Sorry.
That's fine. And just, I guess, for the committee as information, when we talk about heritage, the definition for the Heritage Council is a heritage listing does not have to be one of historical value. It could be a place recorded in time for future historical value.
Correct. So again, there's maybe a public misinformation that heritage relates to, colonial times, that sort of stuff. We have stuff we have places on the Heritage Register that are from 2017, nominations from as recently as 2017. Again, the Wayfield Walk-Off, I think it was recently 60-year anniversary of that. So we're not necessarily talking about, places built in 1897. We're talking about places up to the modern era which have become of significance to the Northern Territory.
And I guess the Chair did take the opportunity to talk about if heritage was prescribed in the legislation as an exemption, a no-go, along with the Aboriginal Areas Protection Authority legislation and Indigenous protected areas, the Heritage Council would be satisfied, wouldn't be suggestive of any further legislative amendments.
Are there any further questions from the committee?
Thank you.
I'd like to thank Mr. Randle Walker for his time today. Thank you for the submission, thank you for coming in, and thank you for the time jumbling up. It's very much appreciated. The committee will now break until 3:15 p.m. when we'll be talking to Miss Catherine. I'm happy to bring it up. If Catherine McLeish would like to go now, I'm more than happy to see you now than in half an hour. Thank you, Randle.
Thanks so much.
Yeah, I'll join.
While we're swapping, we're going to...
Yeah, we'll take a 5-minute
rest stop.
quick break.